Hello, everyone. First of all, I would like to thank Justin Frosini and Riccardo Ramirez Calvo and I'm going to present a paper written within the framework of an Horizon 2020 project led by Anthony Abattini-Net, and the project is called Express 2. In my talk, I will explore the relationship between illiberalism and human rights in light of what scholars, in particular Paul Blocker, have called legal resentment. As we shall see, contrary to what is often asserted in literature, human rights and constitutionalism have been attacked not only by right-wing illiberalism, but also by left-wing forms of illiberalism. And this is an area that I would like to explore. After all, as we know, the revival of cash meat theories has not been monopolized by right-wing thinkers only. Before getting to into the central part of my argument, however, I should define what I mean by liberalism, and afterwards I will identify some elements that can be traced back to what I called illiberal constitutional counter-narratives. Finally, building upon this deflection, I will focus on the role of rights, in particular fundamental rights. To begin, let me briefly clarify what I mean by liberalism. I use the term to describe a political and constitutional transition away from liberal values. In this sense, I follow the distinction between anti-liberalism and illiberalism, the distinction that has been developed, among others, by Neil Walker. Anti-liberal regimes, such as the contemporary China, have never embraced liberal constitutionalism and values in the first place. Illiberal contests, by contrast, emerge within constitutional democracies that once were committed to the preservation of liberal values, that have gradually weakened liberal principles from within. Hungary and to some extent Poland, that at least under the previous government, are obvious examples of this trend. This distinction between anti-liberalism and illiberalism is important because illiberal actors don't reject constitutional law as such. Rather, they reject constitutionalism understood in a normative sense, and I will come back to this point later. This whole theoretical debate, however, reveals that illiberalism is a fuzzy concept that cannot be defined autonomously, in the sense that it also depends on what we mean by liberalism. Probably the only common ground these different views and approaches have is liberalism seen as individualism. Indeed, for instance, when looking at Viktor Orban's rhetoric, one can realize how individualism is targeted by illiberal leaders, and there are many official speeches that can confirm this. These are some of the features that we can find in illiberal context and that characterize the illiberal constitutional counter-narratives. Again, this is a formula I have used it in my works to refer to the cherry-picking and instrumental use of the categories of constitutional law made by illiberal populists. I use the term constitutional counter-narrative because, like Frankenberg and others, I believe that constitutions are also narratives, in the sense that they have a story to tell and the symbolism to convey, particularly the European constitutions born out of the memory of evil, as Todorov and Veka will say. Indeed, supporters of illiberalism are very much interested in constitutional law and constitutional theory, even though this might seem counterintuitive. Why? Because they are interested in making the constitutional law a part of their playbook. And constitutional law in this context becomes a tool through which to petrify the image of the enemy, according to a dynamic of weaponization of constitutional law. This occurs through the instrumentalization of the moral, religious, historical argument of tradition. In this context, the Constitution becomes above all an instrument of government that loses its counter-majoritarian flavor. Rights, and this brings us to anti-individualism again, are perceived as factors that fragment, that risk undermining solidarity and community values, as we will see. the construction is based on an organicistic reading of the concept of the people, and the manifesto of this illiberal constitutional law is the 2016 ruling of the Hungarian Constitutional Court on asylum seekers, an important ruling that paved the way to an important constitutional reform amendment approved later. Indeed, the striking example of this trend of weaponization of the constitutional law is provided by certain norms of the Hungarian basic law, for instance. I mean, article letter R.4, according to which, I'm quoting, the protection of the constitutional identity and Christian culture of Hungary should be an obligation of every organ of the state. Another example is given by Article 67 of the Russian constitution, according to which the Russian Federation honors the memory of the defenders of the fatherland, provides the protection of the historical truth. The historical truth, if I wanna stress this point. Against this background, we can now move to the main part of my talk. Scholars have already explored the relationship between illiberalism and human rights, pointing out how, especially in conservative illiberalisms, the weaponization of constitutional law has had a huge impact on the rights of free speech, religion, and many others. Here you can find the combination between a certain dose of communitarianism and the instrumental use of the religious argument, as Susanna Mancini, Nausicaa de Palazzo, Frick, and many others have highlighted. From this perspective, liberalism is seen as undermining traditional values, in particular Christian ones, and the EU, especially by Viktor Orban, is seen as a part of this threat. This deflection, however, leaves out attacks on human rights that come from left-wing forms of liberalism. I'm thinking of those deflections that see human rights as projections of neoliberal power structures, which must be challenged. Although I like the anti-colonial flavor of this argument, this view sometimes forgets the subversive potential that human rights have traditionally had in their function of contesting power structures. In this, the history of the civil rights movement, it is a powerful antidote to this way of representing, to portraying rights. Now, to answer the question of how both left and right-wing illiberalisms conceive of human rights, we must introduce the concept of legal resentment, which is a bridge connecting these two forms of illiberalism. Legal resentment refers to how illiberal populists approach legality. As Paul Blocher argued, I'm quoting, the legal resentment of populists refers to a critique of what is perceived as an excessive form of legalism. In other words, human rights, whose protection is part of the normative mission of constitutionalism, would encroach upon the domain of politics and would impede it from performing its proper role. Put differently, the sphere of politics is perceived as being overly constrained by rights that remove certain issues from the reach of majority decision-making, and this, according to this argument, is undesirable. Indeed, human rights, which become fundamental once they are protected by the Constitution, identify areas of non-negotiation. And this criticism is frequently combined with the rejection of what these authors have called over-constitutionalization, in the sense that, according to them, the constitutional law is occupying the space of politics. And the works by Paul Blocher are extremely useful, to explore and to analyze these arguments. So how do liberal leaders attack the fundamental rights and human rights in general? They do so by creating a false dichotomy between democracy and constitutionalism, seen as antithetical concept. Of course, in this, according to the supporters of illiberalism, there will be a particular tension with that particular form of historical constitutionalism, which is post-World War II constitutionalism, a type of constitutionalism that has been enriched by the candidate majoritarian instruments, eternity clauses and entrenchment clauses, and new forms, new and strong, I would say, forms of judicial review of legislation. Antonio Negri is frequently evoked in this debate, since he once theorized, I mean, this opposition between democracies and constitutionalism in his works, especially in his works devoted to the concept of constituent power. Indeed, for illiberal leaders, the only acceptable, and for populists as well, the only acceptable form of constitutionalism is a weak version of it. In other words, a type of constitutionalism which should open up to the claims of a sort of permanent constituent power. Naturally, this idea is then instrumentalized in order to transform the constituent power into a vehicle for legal dissentment. Here, the constituent power, when used by illiberal populists, is frequently understood a la Schmitt, who famously manipulated the concept originally devised by Sayes. As Enzio Arato powerfully pointed out, populists, I'm quoting, implicitly claim that there is an absolute primacy of constituent power vis-à-vis the Constitution and the rules and powers derived from within. So indeed, for a liberal populist, constitutions are straitjackets, and they tend to occupy the space of constituent power in order to mobilize the people against the constitutional supremacy of the elite, in order to use pure politics against the Constitution. Now, to understand how Schmitt has also been used by left-wing critics of human rights and fundamental rights in particular, it is worth recalling the relationship between constitutionalism and political theology. This is crucial to explore how they see rights and constitutionalism as forms of hubris, as a challenge to political theology. Human rights, especially the fundamental rights, are seen as having to do with constitutionalism as a legal moral theology. Here I'm referring to this important book by Geminiello Preterossi, Political Theology and Law. For these authors, a kind of constitutionalism that dares to disregard political theology is seen as a device, a dispositif for depoliticizing and naturalizing conflicts, seen as the art of democracy. Here, Schmitt is often somewhat mixed with Foucault, and the new Schmittians are terrified by the prospect that the political theology might be replaced by something else. According to this view, legal moral theology will be functional in justifying the agenda dictated by the powers of globalization. And I see a lot of conspiracy theories here, of course. The alleged universalism of constitutionalism, combined with its low political intensity, would turn out to be profoundly unjust. That is why these authors reject a thick version of constitutionalism. But constitutionalism, in my view, must be thick, otherwise it risks losing its normative character. To debunk these approaches, we can argue that, of course, the constitutionalism does not aspire to replace political theology, but rather to limit the political, right? So I hope I have contributed to reflecting on the dangers that come from both forms of illiberalism described in my speech, and I thank you very much for your attention.